Hello and welcome. This is the crash course for NCA Administrative Law exam. The reason I'm doing this course is because I saw that there are a lot of students who are cramming and reading through a lot of material, but they do not have the depth knowledge. And I was facing the same situation when I was giving my NCA exams. So I realized that I have to create something which gives you the in-depth knowledge because, see, NCA exams are not about how much do you know about the Canadian law. They have already given you the syllabus and they basically want you to learn, have the in-depth knowledge of those concepts that they have asked you to learn. So if you do not have the in-depth knowledge, you will always be confused when there is a question in front of you, and you will be thinking, that if you are doing the right analysis for a particular question, or are you approaching it correctly? Did you identify the issues correctly? So I want to make sure that you do not, get confused when you are taking your examination. So what I did is I have prepared this um, PDF, which is about 33 pages approximately. What it covers is, let me just go through the index here. So one of the part here is this, which basically talks about the issue identification. So if you like, you can actually take this PDF in your exam, and then whenever you have this, whatever question that you have in front of you, if you have read this particular PDF, you will be able to identify the issue easily. And the problem with the administrative law exam is that most of the times, and many times I've heard from many people that they will only give you, NCA will only give you one question for 100 marks. If that happens to you, it will be really hard for you to pass the exam if you do not know how to identify the issues. So that's what this first part is about, that what are the issues in a particular scenario that has been given to you, right? Like, second thing is I have divided the case laws in two sections here. And now understand this. No question will come that has not went to the court so far. What it means is that all the case laws that you have read, or all the cases that went to the court in real life, are the scenarios that you are going to face as your question in your exam. Because all the questions that are related to the analysis, like the procedural fairness or the standard of review or the legitimate expectation, whatever the concept they want to check, it is highly unlikely that they will create a scenario on their own and assume that this is how the court will be, uh, react to this particular situation. This is how the court will do the analysis to a particular situation. So what it means is that you have an edge here. And that edge is, if you are reading all the case laws that are mentioned in your subject syllabus, then you already know that what are the questions that might come. So they will only ask you about those scenarios and situations that have already happened in real life. So what I did is I've defined that what are the case laws that are important mentioned in your syllabus by the area of administrative law, that this particular case is about the legitimate expectation. This case is about the impact on a person. Then this case is about the impartial arbiter, or like the impartial decision maker. So the next one is the case law summary. When you are in your examination, you do not have time to go through the whole case, right, and figure out like where was that important line that is required for you to able to put as your case law, right? So what I did is I have provided you a summary here in section 3 of this index, and then this has almost all the cases that you would require during your examination. And the last one is the IRAC skeleton. This is like the answer that I have already written. What you need to do is, next time you see a question, you pick this skeleton and start changing the details and writing your own words based on the scenario that has been given to you, right? So these are the four things that I'm covering over there. So you can download this from my website. I will give you the link here on YouTube as well. Going further, this has other two sections as well. So that was one of the sections. The second section are these two charts. The first chart is going to talk about the procedural fairness, and the second one is going to talk about the standard of review. This will help you immensely during your examination because your examination is only for 3 hours. You do not have all the time in the world to really, go back and, you know, um, keep on writing again and again that what are the steps that you need to follow when you are, doing the standard of review analysis for a particular situation. In that scenario, you can just open this up and then see that like where this is moving to and then reach to your conclusion here. And then so is the case with the procedural fairness where you can, just go through which is the source that is, um, triggering the procedural fairness. So I will go through that how do you need to use it, but then these are the two navigating charts that I have given on the very first and the second page, so you do not have to turn your pages. Second, as I said, is this PDF for about 12-15 pages for these four sections. And the last one is this. So this one is giving you the explanation that how things work, like the knight three prong, like what does it mean? How does it work in real life? Right? So you will be able to see that from this PDF. Now I'm going to go over this with you in this crash course. What I will do is, so that we do not, waste enough time because we don't have enough time, at least on the video. I won't be able to cover all the intricate details that you would require. So what I will do is I will go over and give you as much as I can so that you are confident. So the message that I have for you is if you are giving this exam for the first time, then you must make sure that you understand the you know the bigger picture. You understand that how things actually work in real life. If you do not have that idea, like I did not have it when I started learning reading for the administrative law for my NCA exam, I was lost all the time. I was like almost guessing every time, even though I read these things multiple times. Just little bit of change in the details and tricky questions actually, really got me. I had to spend enough time to come back to my, learnings and say that, okay, I need to approach this in a certain way. So I think you are possibly facing the same situation if you are, because, I understand that you are from a different background and everyone is, you know, trying to make and start their process of becoming a lawyer here in Canada. So I think that if you're doing it for the first time, then you really need to start with the approach that you must understand that how things work in real life. If it if this is your second or the third time, I have an advice for you, people who are giving it for the second time, that you must pass your exam in the second time because third time is going to be the worst. Like you will have tremendous pressure on you at that point of time, and there is a lot going on at that point of time in your head. So second time is really crucial. So I would say that like go through this PDF if you really want to have um, some support, then you can always reach out to me. Now going further, so what is, let's talk about the actual law here, right? The administrative law here. There are only three pillars in the administrative law. The first one is the procedural fairness, where you are more likely to get the question from. If it's only one question, they will actually check almost every concept that there is from the procedural fairness, from the standard of review, and from the remedies that could be available to a person. Now, these are the three pillars, right? Like these are the three, uh, the rule of law. That's how the administrative law is executed. Now, I will move further because this is actually prepared in such a way that you should be able to navigate it properly, but for teaching, this is not properly compiled. So what I'll do is I'll use our very first chart for the procedural fairness and talk about what does it mean. To make things way more simpler, if a question is about that a decision, how a decision is made, then this is the procedural fairness question. If a question is about what was the decision, then it's a standard of review question. Now I'll give you the distinct, the difference further. The way you want to distinguish these two concepts here is the procedural fairness has nothing to do with the outcome. So if you are going to have the same outcome even after changing the process, the way the decision was made, but you are ending up with the same outcome, even then the procedural fairness is owed to you. But then that is more about how the decision was made, like what was the process in order to reach to the decision, right? So all the departments in your government would have some sort of a policy, some sort of a regulation, and the steps that they have to follow when they're making a decision. For example, you have applied for a liquor license, right? Like license for driving, or liquor license, or shop license, or any license of that sort. And then what they will do is they will take out this chart. I mean, not literally, but they have this process, right, to follow that. Have you submitted the required documents? Are you eligible? Are you a citizen? Are you a PR here in Canada? Or do you have the age of consent? Or are you of sane mind? And so on and so forth. Like they will check all the things that basically are part of their process. If they are not following that, and then they are saying, you know, because I don't feel like giving you the license, I will not give you the license today. Now that's not the process that they should follow, right? So there is obviously a procedural fairness question coming into the picture in such scenario. But if you think about it, like, is everyone going to owe you the procedural fairness to start with? Is what you need to ask this question, right? So let's say the very first question that will come, or that could come, is there is this institution, there is this, and more likely this can be a question related to a college, because college is more of a, mm, it's neither, it's funded by the government, but it's managed by the private parties under, the contracts, employment contracts with these, individuals. They could be the directors, they could be the principal or professors, and so on and so forth. So if the management of a college is privately managed, then you cannot really claim that they owed you the procedural fairness, because that's essentially a private organization. So the procedural fairness is only for the question of procedural fairness is only for the organization where that is governed by the government, or it's a government entity. It can be a quasi, pseudo, how do you say it, the pseudo organization as well. And as I said, like in the case of college, so it college, for example, there is this one famous case law, and we'll talk about that. If the management of the organization is hired, or are the government officials, in that scenario, that is essentially a government body, because the management is the government body. The management is uh, the government itself, essentially, because they are hired by the government. They are on government payroll. They have, they are reporting uh, to the government. So they are basically essentially a government employees. And if that's the case, all the fundings for a particular college is coming from, let's say, by the government. So then this is essentially a government organization. But at the same point of time, if it is just funded by the government or supported by the government, but rest of the management is actually independent of the government and can make their own decisions, and they do not have any influence of the government, then it's a private body, right? So you have to make those differentiations when you're reading the question. But that's the very first step, right? Like generally people forget that there is a step before going into the procedural fairness, that if this is the organization that actually comes under the government umbrella, where you can go to the court and say that this particular government uh, organization did not follow the procedural fairness steps, did not uh, you know did not follow the procedural fairness steps, and hence I'm coming here to the court to to claim the same. Now, next thing that you need to check is that what are the sources of procedural fairness. Like you would need some legal basis, right, to be able to go to the administrative body where you are saying that you need a judicial review of the decision that has been made by an organization. But what is the law behind it? Like who gives you that power, right? And that power comes from these five loosely written heads over here. So now specifically for the very first thing that we need to see is the enabling statute. For enabling statute, we need to really don't have to worry about it at all. And I'll tell you why. Because nobody's expecting you to remember all the laws, right? All the laws of Canada. So they are only expecting you to understand that what does procedural fairness means. So what they will do is, if the the source of the procedural fairness is within the statute of an organization or within the statute, then they will mention that within the question, that section 43 of particular statute says this. You will know right away that this is the enabling statute. That's what they're asking, and then the source here is the enabling statute. So you can just write, because the department already has the enabling, the section 43 or 57, whatever that section that they are going to give you, and this is already written, and then they are going to follow. Hence, the enabling statute is the source of the procedural fairness, which should be owed to a person or the applicant, or like whosoever that person is. So you already know that for sure that where the procedural fairness um, source is coming from, right? Similarly, the second one is essentially the same. It's the statutes, but general procedural statutes. Like these are like the provincial legislative statutes, and these are also like procedural steps that a department should be taking in order to come to a decision. So that's again like going to be there in the examination into the question itself. So it won't be something that you have to remember. So you just have to read through your question, and if you see something like section, rule, procedure, um, or maybe like article, whatever, basically that uh, you know it if it is pointing towards a law, then that's the enabling statute. And general procedural statutes that are already given to the organization to follow. So you don't have to guess anything over there. These are the simplest one. They will not come for more than 2 to 5 or 6 points. Like they will be like 6 marks or something, because like they are straightforward. They are giving you the answer right there. Now coming to the common law, that's the bigger beast, right? Like that's where the whole procedural fairness questions will come from, because that's where you will do the bigger analysis, right? Like what it is about. What does common law means? Like if what it means is that these are the cases that have been decided by the courts over the number of years, and these become the case laws, the foundation, the very foundation of any situation that may arise the next time, something similar to that, you will be able to refer to that and come to the conclusion that because the court said that last time that these are the things that an organization need to check, then you should be checking that from my case as well, because this is the case law, this is coming from the common law, right? So that's where all the analysis part is going to come from. And I'm almost certain if it's a 50 marks question, 25 marks question, that is going to be from the common law. It won't be a 5 marks question, because you're going to talk about the Knight three prong and the Baker five analysis, and the legitimate expectation, so on and so forth. We'll talk about it. Then comes the charter, right? The charter is different from the common law, because that is again coming from the charter, and that is specific about the life, liberty, and security of a person. What it means is that if a person has a immediate danger, or it's about the life, as it says, life, liberty, and security of a person, then you can invoke the charter, section 7 rights of the charter, and go for the judicial review, that because this was not properly owed to the person, and the decision was made without keeping the section 7 of the charter into consideration, then you know you can have your basis over there. So this question will not be similar to the common law questions, but this will be more about that the person would face if the person is deported to their home country, then they will face the danger to their life, something of that sort. Like there, this is actually about life, liberty, and security, right? So, Bill of Rights is something similar, which is again Bill of Rights section 1A and 2E. These are the two sections that you have to read, have to remember, and they are again about the protection, the provide protection for individuals' rights and fair hearing. Individual right and fair hearings, right? There again, if you read this again, we'll talk about it. The Charter and the Bill of Rights we'll talk about in details. But as of now, you can remember that the Charter and the Bill of Rights are again, these are the written sources coming from the Charter and the Bill of Rights directly, and they are more about the bigger, higher, uh, uh, like you are owed the procedural fairness when it is about one of these two or three issues that are given into the Charter and the Bill of Rights. So those are the specific situation and issues, and you will be able to identify right away, like when I will talk about it, like how to differentiate between the common law question versus the Charter and the Bill of Rights. It could be possible that the question will be somewhere mix of both, but then you will be able to actually identify that as part of the issues. We'll talk about it. Now, coming further, once you have identified the sources, then you have to apply, right? The very first thing is, now we'll talk about the common law, the threshold test, right? Determine application. Let me, okay, if this is clear. Okay, determine application. Apply the identified triggers to the specific facts of your legal scenarios to determine if the legal threshold for procedural fairness has been met. And this threshold is here. Okay, I'll show you in the presentation below that what is that threshold. And then remember, then the last one here is the Baker factor, right? One is if the procedural fairness is owed. Second is how much procedural fairness is owed, right? If it is there and how much it is there. These are the two things, and then you need to put them step by step, and that's what I was talking about in the IRAC format, the skeleton that I've given in the document here. Common procedural issues depending on the case, content issues, like this is specific, like we'll go below, right? And then this is the anatomy I was talking about. So the very first thing is it the government action? If it is not a government action, you'd have no case over here. Like you cannot really apply to the administrative body to say to a private party that they owe me a procedural fairness, right? Like they do not owe you procedural fairness because they are the private parties. But here in this scenario, government action impacting an individual. Is that the case? Go further. Second, is there a statutory code, right? As I said, that is it a statute? If it is not, then it's a common law. If it's statute, you will already see that written in your question. If it is not, you will not see that. That means it's a common law. Now, trigger we are going to talk about. Does it cross the Knight three-prong threshold without hitting an exception? Exception, keep it aside. Does it cross the threshold? What is that threshold? The threshold here is this one. This is the Knight filter. Remember these gears. The very first thing that you need to check is the nature of the decision. So if the question says, the administrative body made a preliminary decision that this person cannot take the examination for next 1 year, and then they will decide the rest of the situation once the case moves forward, or like once they have made their final decision. But as of now they cannot take uh, a student cannot take the examination for next 1 year. Now remember, these are very specific cases. What do you read in this? One, the decision is made preliminary on a preliminary basis, and second, they are barring a student to take the exam for next 1 year because until they come with the final decision. Now two things are happening over here, right? What if you go to the court at that point of time and say that, they have barred me to take the examination for next 1 year. I want to challenge this decision because the procedural fairness was not owed to me, was not followed. The procedural fairness was not followed there. And then court will say that, you know what, this is a preliminary decision. Then why are you coming here? Let them make the final decision, then we'll decide, right? That's the nature of decision. But as I said, they said that you cannot take the examination for next 1 year, and this is a preliminary investigation decision. And once we have made a final decision, we'll tell you what exactly happens later on. They have actually barred you from taking the examination. Now the result, the impact on you is final, isn't it? Like you are really stopped from taking the examination. So this is going to happen to you, like you are going to be late on your graduation or whatever, course or uh, you know course you are doing. So the impact on you is final. What you can argue over there is, if the impact on you is final, you were supposed to take the examination next year. That was the main thing that you wanted to do, but somehow the administrative body has barred you from taking that examination. And along with that, they said this is a preliminary, decision. But then it doesn't matter. That's exactly what you wanted to do. This is a final decision for you. This is the final outcome for you, because for next 1 year you are stopped, barred from taking the examination, and that's the exception. So if the impact of that preliminary decision is final in nature for you, then you are allowed. And then the nature of the decision is actually of the final decision, even though they keep on saying that this is preliminary, right? So that's the nature of the decision. So next time when you see a question, what you need to remember is it temporary, is it final? If it's temporary, what kind of impact it has on the person, right? Is it kind of a final nature decision, or is it, still preliminary, right? Like has no impact on that person, so the person will still be fine with that kind of a decision. Second one is the relationship. Why relationship matters is because a relationship is where a person has the authority over the other person, a boss and a boss and employee, and then employer-employee, and then there any other relation where the one person has more authority over the other person. In that scenario, it will be important because if you have authority enough, if you are the person who is not really compelled or bound by the decisions that have been made by the other party, and you can cure it yourself, then why would you appeal a decision? You can just change the course, right? You can just order within your capacity that I'm not going to follow it. So that's the kind of nature that we have to look into. And the third one is the impact. Is the impact there or not? Right? Like what if the two gears are here, the nature of the decision is final, the relationship is if an employer and employee, but then there is no impact. Does it really matter at that point of time that you need to really appeal that decision? If there is no impact, then chill, don't do anything about it. But then you will actually spend your money and time only when you have an impact on you. So you need to read that question closely, if there is an impact on that person and how much impact is that. We'll talk about that impact, how much, as I said, this one is a threshold. If these three are aligned, your question is going towards common law. The night three prong here, which I showed you, is triggered. The next step is the how much procedural fairness is owed, right? So you have understood this fairly, I believe. And then we go for the procedural promise. Just give me 1 second and let me see if the recording is long enough or not. Right now it's about 34 minutes, 20 something minutes. So just give me a second. Okay. The next thing is the procedural promise. This is also you need to see at the same time. What is the mechanism here, right? And I'll show you that why this PDF is good enough for you for the examination. Clear, unambiguous representation or promise by authority, reliance by an individual creates an enforceable legitimate expectation of procedure. What does it mean? Now imagine that there is this uh, person of authority. There is this MP or MLA comes to your organization, comes to your town. You are a rich guy and tells you that why don't you build a hospital on that empty land, and once you do, I will give you the license to operate. And then you go ahead and you build the hospital, you spend millions of dollars, and then when you go to the MP, the department, and then he says, you know what, I won't give you the license. What happens then? The expectation was that the person of authority made told you something, that how you will be able to get the license. You did exactly that, but then he says, I'm not going to give you the license, and I'm not bound by any promises. I'm a politician, I can do that. But then there was a procedural, there was a legitimate expectation that if the the promise was within the power of that individual, of that official, right? And then that was a legitimate expectation, that promise made a legitimate expectation that if you do certain things, then you will get the license. But then later on, they cannot say that, no, 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 I am a politician. I say this all the time. But then, how do you know that, you know, how do you apply this to the, if you get this question, let's say of similar nature, right? How do you apply this using this PDF? So what you need to do is, let me show you something right here, what it is about. So I gave you this real life example, and this was actually a real life case law here, the one which I just told you about, the hospital. So let's see if it is there. Okay, here. Mount Sinai Hospital Center v. Quebec. Legitimate expectation. You have these many case laws. You know what? Pick one of those. But this one was more appropriate in this scenario, like because I remember this one. Enforces clear, unambiguous procedural promise made by official acting within their authority. Remember, if they say something outrageous, then that's not the legitimate expectation. What they said is within their power, acting within their authority, provided they do not conflict with the statutory duties. Yeah, that's fine. This is the case law. Next time you see something, you go over here and then you apply the same logic. This and then you can in fact tell right there, oh, this is legitimate expectation. Start writing. How do you write? You can just go to this skeleton issue, threshold issue, keep on writing, and then I think your answer will be good later on. So you got what I'm trying to say over here. Like you will have enough power and time and knowledge and confidence to be able to write your question once you have something like this. Because I did read a lot of notes, but they were like almost dense all the time, and they were good, honestly. The notes that I refer to, but I actually bought a lot of books for my NCA exam. Like I like to study from the textbooks a lot. So that was one of the things that I was doing. But then, as I said, NCA examination is not about the how much you are reading, vastly. It's about how much depth you understand of a particular topic. If you just follow the syllabus and keep on reading those case laws, I think if you read about, now let me summarize it, 60 case laws, um, 60 case laws, and then 15 concepts. That's it. That's all. That's all you need. You understand 10 to 15 concepts from your administrative law. You read about 60 case laws, and then that's it. Like that's all you need to pass your examination. So you don't even have to really make it like a huge deal, because I only understood this once I passed. I did not understand this thing, that it's not as big as, it's like it's much more manageable if you see it clearly from from a distance, that things are easy here for the administrative law. Anyways, we'll go further, then talk about the, we have done this one, that gears. These are three prongs anyways, like three prongs, so you can remember that either way. Then talk about the Baker 5, right? Apply the Baker dial. I'll tell you what does it mean. So Baker dial. The Baker dial basically tells you here, if the decision, the nature of the decision, the statutory scheme, the impact on individual, the legitimate expectation, and agency choice is on the left hand side, then the minimum fairness is owed. So if it's a judicial, adjudicative like decision, that's where the uh, maximum uh, procedural fairness is owed to a person. As I said, we are done with if the procedural fairness is owed. Right now, we are assessing how much procedural fairness is owed. If the process of the decision making is so stringent that it almost looks like a courtroom, then you owe a lot of procedural fairness. Like you owe the maximum procedural fairness to that person who is you know, uh, being made for the decision. And then second one is the final decision with appeals, or no appeal mechanism provided. So is it the, do they provide, or does the procedure of that administrative body provides the mechanism to appeal that decision? If yes, then the less procedural fairness is owed because that can be corrected at some point of time in the stage, and that's a logical step. But if they do not provide the appeals mechanism, right, then they should be really serious about it because the person does not have anywhere to go afterwards. Where should I go? Like if I'm denied my license, then I can't even appeal. So you should be really, serious about it, like when you're making the decision, isn't it? So that's why the dial here, if it's towards the no appeal side, then it is the maximum procedural fairness. Again, impact on individual. If the impact on an individual, let's say, um, about the livelihood or the um, a salary, a job, or livelihood, or like if it's about the job of a person, then you should be really serious about it, isn't it? But if it's about, let's say, uh, a very small inconvenience that could occur to a person, then I think the minimum procedural fairness is owed because even the government organizations are busy, like they are overworked at this point of time. So it's very understandable that if the impact on you is not that huge, then you should not expect really high um, level of care from the government body. Then the agency choice, basically what it says is the statute really rigid or does it allow to choose the own procedure? What it means is if the statute gives you very specific steps to go into, then you allow like minimum fairness, right? Like, because all the steps that were supposed to be there are actually covered by the statute or the procedure or the rules or the act, right? But if it actually allows the decision maker to make some fair level of decision using their own understanding at that point of time, maximum procedural fairness is owed because you want that person to be serious about that responsibility that he's getting. So this, how will you be able to tell? You will be able to tell in the examination that how much procedural fairness is owed, and you will get hints like the X person uh, will lose their job if something is not done on time, or if X person has been fired from this government organization without giving any notice and chance to clarify from his standpoint of view. So maximum fairness is owed because it's about the livelihood. But if it is about, um, let's say a license renewal where they cannot renew the license for next 15 days or so, I think then minimum procedural fairness is owed. But then you will be able to again look into the question details and come to this page and see that what it is about. Is it about the final? Do they give the do they allow the appeal for the decision? Do they allow the um, the person to make the decision maker to be able to decide fairly on their own, and on the basis of those facts you will be able to apply and answer your question there. And these are the Baker fives, by the way, like nature of decision, statutory scheme, impact on individual, legitimate expectation. As I said, legitimate expectation comes twice. Like you have to check the legitimate expectation right along with the three prong, right? At that point of time, you can check the legitimate expectations, and then the choice, agency choice, right? Like, so these are the five. Now let's go above. Now let's go above. Now let's go above. Execute the procedural print. Let's talk about this for a while. Right to be heard, and then you obviously do not want a biased decision maker, right? So right to be heard, the notice, the discovery, the delay. These are the words that you will see in your question where some sort of contention is there, right? The notice was not given to the person or the person was not given the choice or time to be able to hire a counsel, or the disclosure was not properly done to the person who was complaining, who is complaining basically. There were some sort of delays, hearing nature, like what kind of hearing was it, like the written hearing, or was the person able to do the cross examination? That will basic. So here, that's the one. Cross examination, post hearing reasons. So these are the things that comes under the right to be heard, where you will see that like what are the things that were covered within the situation, and then obviously you do not need a biased decision maker. So pre-hearing, we can talk. This one is too much in details. Even this one, like, but if I give you um quickly, elected officials can have the um their mind made up. Like they can have the opinion biasness towards a particular situation because they are there for their opinions, right? Like people like their opinion or dislike their opinion, that's how they get elected. But for judges and adjudicators, it has to be in the green zone, and they cannot do the prejudgment or close-minded about it. So that's the again, the the decision maker has to be impartial. Going above once again. So once you have done all that, you have done your procedural fairness work. But sometimes you get questions where you have to do both of them, right? You can have a procedural fairness issues, and then you can have these standard of review issues. Now, standard of review issues, as I said, is more about what was the decision and not how the decision was made, right? What was the decision is, I just explained you. How the decision was made is this. What was the decision is standard of review. Recently, there was a case called Vavilov, and then based on Vavilov framework, then there is a Vavilov framework after this, which basically presumes that the standard of review is reasonableness. Before this, there were many other cases, like Dunsmuir was one of Dunsmuir was the standard of review. After that, I think it was 2019 when the standard of review was changed. So Mr. Alexander Vavilov, I think he was 25 at that point of time, who was um, whose parents were Russian spies, and there was issue related to his citizenship, that if he is Canadian or not. Like even though he was born in Canada and all the time he lived in Canada, but because their parents were not legally here in Canada and they were spies, and he was born of the the ambassadors of Russia. So if I remember correctly, that's what the case was. So the question in front of the court was if Vavilov should have the citizenship of the country he was born in, which was Canada. And then they decided that that the presumption will always start from the reasonableness for the standard of review. So what they will not check if the decision was correct, because I mean, think about, like, for courts it is essential that they will be making the correct decision on the basis of the laws and the acts that there are. They won't, courts itself won't be you know doing the decision making on the basis of reasonableness, right? Like they want to be correct. They want to be as correct as possible. But for the administrative body, they would say that, like, our presumption is that the standard of review for us as court will be reasonableness. That was the decision reasonable enough or not? But that can that can have exceptions, right? Like, so not all the time. So the standard of review can be correctness as well, on the basis of this chart. So how do you see that? Does the statute provide for a standard? Yes, apply the standard. So the standard is check governing legislation. If explicit standard is written, then use it. Done. Right? Initial was presumption, but then the statute provided for a standard. If the standard was provided, like what kind of, was it a reasonableness standard? Was it a correctness standard? If the statute says specifically in written words that the standard of review for our statute is going to be correctness, then there is no question further. If it says reasonableness, then there is no question further. But if the statute is silent on that, right, then you need to see, does the statute provide for an appeal, for a right of appeal? So if yes, if the right of appeal is there, then determine the nature of question, categorize the legal question being appealed. So you can only appeal the legal questions, right? The question of law or the question of facts or mixed facts and law. So the question of law is like, if the appeal involves pure question of law, then correctness applies. As I said, if it is the if it is the appeal related to the law, that the law was not applied properly, right, then this has to be the correctness, right, because it is about the law. The law has to be correct and not reasonable, right? So similarly, if it is about or if the facts are not properly taken into the consideration, or it's a mixed facts and law, right? If inquiry is fact based or mixed of law and facts, then this standard is utilized. And what standard is this? This is palpable and overriding error, right? This is more, it can come as part of an analysis, but it won't be like really high point question, because that's not generally like you would see as even in real life as the point of concerns for the courts as well. And we can actually dive this in details. Then go further, and then you see that the decision 3 is the categorical exceptions for reasonableness, and these are the exception. Like if yes, then you have to go here, but if it is appeal is not there, then the only option that you're left with is one of these three exceptions. The exceptions are, if it's a constitutional question, then obviously you want to go to the court and talk about it, that this is the constitutional question that arised out of the standard of review, and hence I am coming here because the decision that was made was not correct. It's a it's regarding the constitution, so the court has to decide over there. Then the general question of central importance, like something which is important to the whole legal system, and it impacts the legal system at that kind of a question. I'm sure the standard is really high over here when it comes to this exception. And the third exception is the jurisdictional question, like which jurisdiction is applied. Is it like the federal, is it the provincial, where is exactly? So it's regarding the jurisdiction between two or more administrative decision maker, where should the decision go. And then the standard is correctness. Obviously constitutional, you do not want to have the constitutional question on the basis of reasonableness, so on and so forth. And the last, if it's not about it, then the final determination should be the standard of reasonableness is the final is the standard of review. So if nothing out of these, then as we started with the presumption of reasonableness, this will end with reasonableness. So this is what the chart is about, and it's quite cool, right? Like you will be able to follow this chart and come to the conclusion. And how you will see that, like what it will say is that the constitution question, like it has something about the charter 7 section 7 of the charter rights, then that can come into the picture here. And then the standard of review will be correctness at that point of time. So even though you will see that as part of the reasonableness too, you can see that as part of the correctness here, the standard of review too. So that one question will cover two concepts, and depends on the question. Like we'll cover questions at some point of time as well for the administrative law. Okay, and then this is it. Aim to finish with 10% of your remaining time. These are some things that I've just mentioned over here. That what are the things that you should really focus on, because when I was giving my NCA exam, it was 3.5 hours, and then some of the subjects were 3 hours. But then I remember like people before me used to get 4 hours, because that's when the NCA switched to the computer-based examination. So people used to get 4 hours and 3.5 hours. Right now, people get 3 hours. So you don't have enough time to really spare and think about it. Like you really have to be really fast and start typing as soon as you have something, the question paper in front of you. So I really understand that you will not want to waste your time just analyzing that what this concept is about. So what you would want to do is you want to have enough resources ready and read enough case laws, so that as soon as you read a question, you have something pointed towards your material that says, I have read this case law, something similar to this situation, let me apply that. And then you can, as I said, like go by the area of administrative law, pick from here, and then start building your question answer from there. So this is about it. And as I said, I will share this with you. um, I actually forgot to talk about this one. As I said, common law section 7 triggers, and then the Bill of Rights triggers. But then I can actually cover that at some point of time in a different video. Next, I will do the constitutional law, and then I will actually talk about some of the um, other subjects that are related to the NCA. So, all right, so this is it for today, and thank you very much.